Welcome to the Success Agents Podcast, where we deliver weekly guests that bring insights to the elements of your business to become more profitable with skills and knowledge and tools. Help you with more automation so you have less procrastination with your host, JP Fluellen. Hey, what's going on, guys? JP's back in the house. We are here with another episode of the Success Agent Podcast. Today we have such a fantastic guest. This has been a long time in the making, probably going on 9 months. We've got a great guest today, Ronnie Lopez. He is an attorney, and he has a practice that focuses primarily on transactional work, including contract drafting, disputes, corporate and limited liability company law, real estate development, creditors' rights, and real estate planning administration. Ronnie has co-authored chapters in the professional publications on Wyoming law related to receivership, foreclosure, as well as covenants against competition. Ronnie is engaged and active in his community. Ronnie serves on the board of directors for the Cheyenne Leads and is the secretary of the board of the Boys and Girls Club of Cheyenne. And Ronnie has served as many positions in church, including bishop of his ward, the Church of Jesus Christ of Latter-day Saints. And when not working, Ronnie enjoys spending time with his family, watching and playing all types of sports, hunting, fishing, and enjoying the outdoors. Ronnie, welcome, dude. I am excited about this. We had a little technical glitch there, but we got it figured out, I believe. So let's just jump right in. Tell us a little bit about what you're working on, some fun things, and let's jump into some fun stuff that hits home, like working with renters and landlord relationships.
Sure, absolutely. And thanks for having me, JP. You're right. It has been a long time. I'm glad we could finally sit down and do this. And our practice, it's pretty diverse. Our firm, we do a little bit of everything. I suppose you've got attorneys here that do primarily personal injury, some attorneys that do only family law, and then some attorneys that do mostly transactional work, kind of like me. And as far as what projects we have going on, there's a lot of diversity in that as well. Anywhere from the multi-million-dollar transaction in Jackson, where we're local counsel for the main counsel who represents the buyer or the lender or what have you, and we review the documents, make sure they comply with Wyoming law, and help facilitate the Wyoming aspects of the transaction, all the way down to what you mentioned, the landlord-tenant situation. And I got a call yesterday about another potential eviction. Those are always hard. People are looking to protect their rights, of course, and they feel bad at times because they have a renter, and they feel bad affecting their ability to live and whatnot. But at the same time, you have to protect your asset. You have to be able to make money yourself to make your payments. And so, there's certainly a need and an importance to moving forward with something like a forcible entry and detainer or eviction action. I say because most people know it as an eviction. The technical term for it is a forcible entry and detainer. So,
yeah, it's interesting. Like, everybody talks the language, and sometimes they're meaning something and they're actually saying something else. So you kind of have to, it just all depends on who you're talking to. You're speaking French or German, we're all talking. It just depends on if we're speaking the right language. So
those dang lawyers that create all this legalese, right?
Oh, man, it's just like, dude, I don't know that big word. If it's got more than 5 letters, I don't understand what you're talking about, dude. So, what do you see? What's one of the things you see quite often in terms of, I can only imagine you probably get some people that are, trying to DIY their, leases, and then, they have to go to court, and you're just like, dude, I'm sorry, man, this is just a poorly written lease. I don't really know how this is going to hold up, dude, because this is not good.
You certainly, you certainly do have all sorts of things. I've seen a number of leases, all from the 3-paragraph long to the 20-page lease for a simple residential thing, and it's neither of those are very helpful, I suppose. The 20-page lease has so much stuff in it that that is not necessary for, that type of a residential transaction. And the three paragraph doesn't provide enough protections for the landlord typically, and leaves a lot of unknowns, a lot of things that are left to interpretation or unspoken, and then it's, hey, he told me this. No, I didn't say that. Or, yeah, I said that, but I didn't mean that. Or, and you get this back and forth with the verbal amendments, if you will, to that three paragraph lease. And it's better if it's all written out. We've dealt with one recently where it was a family situation, and it was a mess. So they didn't have an actual agreement. And kids started trampling on parents and not paying rent, was occupying multiple properties, and it becomes problematic. The parents got to make the payments and still meet their obligations, and it can be problematic for sure, especially you get to the point where you're trying to enforce rights, and what really was the rent obligation? Well, we've got the history of what they've paid, and then you've got an argument that, well, I was paying more than just rent. I was helping mom and dad, or I was doing whatever it was, and then this really wasn't rent, or they told me I didn't have to pay rent, or whatever it is, that argument, and it becomes harder, I should say, to point to what exactly those terms were. The other thing too that was unique about that situation, and it's opened my eyes somewhat. We got to the hearing on that. In a normal forcible and detainer proceeding, you've got a renter who hasn't paid their rent. You have to post a notice. It's a notice to quit. It provides 72 hours for the tenant to vacate the property. If they haven't vacated the property, you can move forward with filing that complaint, that forcible entry and detainer complaint, and have that served. That hearing is anywhere from 10 to 14 days from the time you file. And then typically at that hearing is when it's a mini trial, if you will. It's your opportunity to convince the judge or show the judge why you're in the right and why the tenant should vacate. Or conversely, the tenant can convince the judge why they haven't violated the lease and why they should stay. It's a very quick summary proceeding, and it's designed to move things along in a very expeditious fashion. This one that we didn't have an actual agreement, we get to the actual hearing, and the tenant, the kid in this situation, demanded a jury trial, and the judge allowed it, and so it kicked it out another 3 to 4 months, to be able to set a schedule for a full jury trial and get the tenant, to be able to panel jury and whatnot, and that tenant gets to stay in the property during that whole time. And so, wow. We've started, as I think we started in our lease agreements, including that waiver of a jury trial, so that landlords aren't stuck in that situation. So there's certainly things that we can protect against in a situation where we prepare a lease that covers what that landlord intends to have covered.
Man, that's insane. Over like $1,000 a month or something to have a jury trial.
Easy
over that, dude.
Yeah.
Wow. That's the first time I've heard of that one. And it might have been just because there was no paperwork that the judge allowed it, maybe.
Well, the statutes allow for probably, it could be surprising, I guess, to some, but the statutes allow for these to be heard by a jury. But as far as the timing of that request or that demand being made, it seemed a little late. But the judge, judges oftentimes will provide some flexibility, so nobody can argue that they didn't get their due process rights, they didn't get their day in court, they weren't allowed, they weren't not allowed to make the arguments that they wanted to make, and they weren't heard by the system. And so I think even if we had something in writing, if they didn't have that waiver of the jury right, they would have still been able to do that. So that's why, in any lease I draft now, I include that waiver just to hopefully help in that event that it happens again.
Well, and yeah, I guess it sounds like too, it wasn't as clear cut as just they didn't pay, you know. I mean,
True enough. True enough.
yeah. So awesome. Well, what other topics do we deal with in real estate? Forming an LLC. So, I've heard many different ways to do an LLC. Like you can just go to the state website and then just file $100 and create an LLC, and then but then is that true? Is that correct? Should you really seek legal advice when you're trying to form an LLC rather than just doing it the quick way or jumping on LegalZoom? I'm sure you guys hear that all the time. Well, I just made this on LegalZoom. Yeah, and then there's that, and so
Yeah, absolutely. It is true. You can form an LLC by paying $100 at the Secretary of State, filing your articles of organization, and you have an LLC. Now, knowing all the ins and outs as to what you do with that LLC, how you can transact business, and those types of things, those are always things we hear about after the fact, of course, right? That somebody may not have been explained to that person. It may not have had a full understanding of what they need to do, and so we do certainly hear about those, and the LegalZooms are there, and they do provide a service. It in my opinion, isn't a very good service.
right.
We've reviewed many agreements been prepared by LegalZoom and other online entities like that, and they aren't complete. They sometimes contradict each other in the terms, and it's kind of almost comical that they provide that product that isn't adequate or doesn't meet what should be provided. So yeah, we would always recommend getting an attorney involved in forming that LLC and preparing those documents. We file LLCs, and kind of as our basic service, we'll file an LLC, form that company through the Secretary of State site, and produce organization meeting minutes and an operating agreement. And those are the basic documents that are needed to get that LLC off and running in action. Now, the statute doesn't require somebody to have an LLC operating agreement, but it does add legitimacy to the company. And most banks anymore will require you to provide them with a copy of the operating agreement when you open a bank account. And so that's something that we'll provide as a matter of course.
The same as the articles, the operating agreement, the articles of organization, or is that something different?
So it's something different. The articles of organization is the document that gets filed with the Secretary of State. That's the public document that everybody can see, and it just provides some very basic information: the name of the company, mailing address, principal office address, those types of things, to get that everybody knows that this is an operating company. Puts everybody on notice, I should say. That operating agreement is the internal governing document for the operations of the company, and it's the agreement between the members of the LLC and the company itself, and between members between each other, of course. And so that's the other thing too. When you have more than one member, you should always, especially when they're not related, that's well, maybe even more so when they are related.
Right.
You should get an attorney involved to make sure that everything's spelled out, and that how you're going to operate business and what rights you have to your share of the membership interests. Who has the management authority? Is it going to be member managed, or is it going to be a manager managed relationship? And all of that stuff is clearly defined in a nice operating agreement. Versus if you go and just file, pay your filing fee, and you don't have any agreement, well, then it's a he said, she said. What rights do I have? What percentages do I own? And all of that can be troublesome.
Sure. Yeah, it's not just it's definitely complicated, especially as you probably are close to this one. When you own a business and you're getting ready to sell it, and you've got your business name on other entities and like real estate, and then you're only selling a portion of that company and it's still in the name. Like you got to make sure that you have some instrument in place for instruction. So when you're going to take care of that kind of stuff.
Absolutely, absolutely. Well, and you have some rental properties and some investment properties and whatnot, and you have those in limited liability companies. And have you found that to be overly burdensome or problematic when you've tried to, operate, I guess, or deal with tenants and whatnot?
Yeah. Well, because I believe in Wyoming, if you have a property that's in an LLC, then if you go to do an eviction, you have to have representation.
That's true. That's true. Now, from just a management standpoint, though, I mean, you interact with those tenants the same way you would if it wasn't.
Yeah, that doesn't change. The interaction doesn't change unless you just want to hire your own manager, and then you can just have them send them over instead of yourself.
Yeah, absolutely. And
outside of that, I mean, you could do that as an individual too, though. So
yeah, exactly. Well, I guess the main point there is that there's a little drawback in the day-to-day management of that company, but there's a lot of upside with the liability protection, right? So you have a rental property. That I would never own a rental property that isn't in an LLC, and the reason is if something happens at that property, and they go to file suit, they're gonna look to the owner, and they're going to name you personally in that lawsuit. Now, you may have adequate insurance, and you may not, depending on what all happens. And so, to give yourself that insulation or that ability to use that LLC as a shield from your personal assets and having your personal name be thrown out there in a lawsuit, that provides huge dividends, I think. And you're right. When you get to a court proceeding like an eviction or something else, you do have to have an attorney represent that entity.
yeah, and for those of you that are have this happen frequently, I would suggest getting if you're going to have to do an eviction, work with an attorney that'll do a flat fee on that. Just because I think it's just cleaner, it's easier. You kind of know what your expenses are, and and then that way. Unless there's special circumstances, if it, obviously if it turns into something much more than just showing up at court that day and, the judge determines what's going on, there's a flat fee for that service. But if it turns into something where there's longer litigations involved, whether it's disputes on damages or earnest money, or not earnest money, but security deposits or whatever, and there's a longer dispute, obviously there's a different fee structure for that. But if it's just a clean cut in and out type deal, work with an attorney, hint that does a flat fee for stuff like that. Not that I've been down that road before. I'm not going to confirm or deny whether I've been down that road before.
Well, you brought up something else that I think is important for people with rental property to understand and to know. When you deal with security deposits, I don't think the average landlord realizes their obligation with those security deposits to at the termination of the lease. By statute, they have a landlord has 30 days to either return the security deposit or provide in writing the reasons or the amount that was withheld and the reasons for that withholding of the security deposit. If that isn't provided within that time frame, then the tenant's entitled to a return of the full security deposit. And so, there are things that I think it's helpful to get an attorney on your team when you're, whether you're starting out or whether you have a rental already, but to get an attorney on your team that is familiar with you and your lease and your process, and that can help provide some pointers and some guidance along the way. I have one client who has a number of rentals and has had a number of rentals for years, and that individual continues to try to do their evictions on their own, even though it's held in an LLC. And every time they have to call me back up and say, "Well, I started this eviction." I said, "Why don't you call me from the get-go? We could, it helps when you keep your lawyer fully informed, and it usually doesn't cost a whole lot or anything to simply, provide some simple updates to the attorney and let them know that you've got something coming up, and that attorney can certainly help, and hopefully save you money in the long run.
Yeah, and I mean, from my understanding, and we didn't talk about this before the show started, but you can usually get an attorney on retainer for a minimal cost, depending on what it is, for a minimal cost. Because if you're only using them 2 or 3 times a year for some questions, I mean, dude, it's worth it. Like, Netflix for realtor or for attorney. pay the monthly fee, dude. Like, I mean, really, like $100 a month, $200 a month to just to be able to just call somebody and get those questions answered, without having to, have to just sit there and be like, well, it sounds okay. Go ahead and put that in there, or whatever, or maybe I should. Yeah, well, if I need an attorney, we'll figure it out later. Like, okay, that was the red flag right there that probably said probably should make that call, because the
Absolutely,
moment you
absolutely.
start
Well,
telling yourself that if I need an attorney later, we'll figure it out,
there are so many times where we have people come in after they've signed an agreement, or when something's gone wrong, and they say, "Hey, can you look at this agreement and tell?" Well, yeah, I can, but it's not going to do you any good at this point. Yeah, I can tell you what your obligations are, but you're stuck, right? And um, I think it pays, again, dividends, to um, get an attorney involved at the initiation of a deal, of any kind of a contract, to make sure that you understand what you're signing, and b, that your rights are protected. I had somebody come in, actually just yesterday, about a non-compete, or it wasn't a non-compete. There was a non-compete clause stuck within this independent contractor agreement they signed, and said, "Well, I just quit, and I need to know what my rights are, my obligations." And we looked at it and said, "You're stuck for a year. You can't do this kind of business." "Well, this is my livelihood." And I said, I hear you, and I'm really sorry, but you signed this document that has this provision in it, and unfortunately, that's you're bound by it. So it's always helpful, I think, in the end, to make sure that you have someone explain to you what you're getting into.
Yeah. Yeah. Anything that's over, 2 or 3 paragraphs that's not in plain English, you probably should make the call. You're like,
Well, I mean, what other
thou shalt
issues or
what?
pitfalls have you seen, JP? Oh,
Um, you know,
what other issues or pitfalls have you seen in dealing with tenants and renters, and in your experience?
so one of the pitfalls that I've gotten into is the line between, um if you have a property that has an issue that's borderline, whether it's a health and safety issue or not, and then whether or not you're actively trying to remedy that, and whether or not the tenant should have temporary exterior housing for a period of time. And I ran into that one, and I was like, well, just because the house smells like poop does not mean that it's a health and safety issue if we're actively working on the issue and mitigating the, you know, seriousness of the situation. And I had a lady, I told her, I said, the house isn't burning down. It's not a CO issue. We're having it actively being worked on until the permanent fix can be done. Yeah, I'm sorry, it sucks. It stinks. Yeah, I get it. But if you live next to the refinery, it stinks too. So, I was just kind of like one of those things where I'm like, we haven't created a health and safety issue. We don't have, refuse pouring out all over the house or anything like that. It was nothing like that. And she was just trying to tell me that she didn't want to be in there while it was doing that. I'm like, I'm sorry, like it's already costing me XYZ per day to deal with the situation. When I can get a permanent fix, I will definitely do that. But I had to wait. It was like a Thursday to a Monday, and we had to wait for a part to come in and to get the situation taken care of. And she was just demanding some other kind of remedy.
remedy. Yeah.
And I was like, you don't have to live here. It's your choice. I mean, it says in there in the lease that if there's a situation that becomes, I think it was the rights to, if they didn't like this fix or whatever it was, and it came down to where we just didn't come to an agreement on that. I gave her the option to opt out if she wanted to, and she chose not to, so she still lives there.
Well, see that, and that's a reasonable thing. If you gave her the ability to move on to something else, then certainly she had the right to either stay there or not, and but and you're definitely right with respect to a landlord has the duty to provide a unit that's habitable, right? Habitability or tenantability is what they call it, and those are some basic fundamental rights. In our climate, a unit has to have heat, right? There has to be running water, a toilet, things like that make something livable. If there's a problem that arises and you're working to fix it like that, where it's a couple of days of delay, as long as the unit is habitable, then you're right. There's really not there's not a lot you can do, especially if you've given them the ability to terminate the lease and move on to something else. And so sounds like you were.
Yeah, and it was habitable. I mean, it wasn't. I mean, she had running water, heat,
Mm-hmm.
all the things. She just didn't like the smell. Like, go for a walk. I mean, get some fresh air. Like, seriously. So on that note, let's move on to creative financing. So, like, I know sometimes in real estate situations, we got buyers that may have bad credit and they need to get creative with putting deals together, or they find out that they're short at the table for the difference for some funds. What are some people's options in terms of like trying to get deals done that may be outside the box?
Absolutely, and those are definitely situations where you probably want to get a lawyer involved. It's a little bit outside the box. It's a little different than your traditional. Here's your contract. We entered into an agreement, and we're going to move forward to closing, and how the company can handle the closing and all of that stuff. But anytime that you're outside of that normal box, I think it is helpful to have an attorney involved, especially just to understand what the different options are. And in that creative finance world, you have a couple of different options, I suppose. Contract for deed is one of the common ones. I don't love those as much from either side of the buyer or the seller, and I think the seller certainly has a lot more rights with the contract for deed. If the buyer misses a payment at all, then the seller can call a default and pull the contract and take the property back. Of course, that requires court intervention to do that, and that process is expensive and takes time. Conversely, the buyer is in that property, has rights to that property, and they may get in a situation where they create liens on the property, be it mechanics liens or something else. And then you, as the owner, are then stuck with that if you take the property back. I prefer doing a note and mortgage type arrangement where the seller actually deeds the property to the buyer and then takes a note, a promissory note, and a mortgage on the property, just like as if you were the bank. That provides a lot of flexibility in the structure. It allows you to provide that either that gap in financing or that the full finance of the purchase price, and provides you some protection with respect to being able to foreclose on the unit or the property, if the buyer doesn't fulfill their obligations to the seller. And in that foreclosure, when you foreclose, any junior liens get wiped out. So, those mechanics liens, anything else that might get put on the property, you as the owner of or the person retaking the property as the seller, you're able to protect that asset, I think, a little more fully in that regard. And so I really think that note and mortgage is a stronger avenue, is a better avenue, stronger document for that type of arrangement.
It's cleaner at the end when everything hits the fan. It's cleaner. It's like you just draw that line and then person takes possession back and then off and running again.
Absolutely. And there is a process to it, but you don't have to involve the courts. You can do a non-judicial foreclosure by advertisement and sale. There's a little bit of expense with getting the foreclosure underway, but it's a lot less than filing suit and having a buyer contest that suit, especially when they have a significant amount of money rolled into it, if they've paid a lot of payments under a contract for deed type arrangement. So
gotcha. That's some new information on that process that I was unaware of. So you don't have to go by if you do a personal note and mortgage, then do you have to go through the 90 days of them right of redemption period then?
Yep, you do have that redemption right. You do have that. So that adds some time to it for sure. They always have that right of redemption, but that also provides them an opportunity to maybe go get traditional financing if they can, or financing somewhere else and pay you off, which was your goal in the first place, right? Was to get your money. So.
Nice. Okay, well, we'll just end on this last topic is 1031 exchanges. So tell us a little bit about those.
Sure. And I know the basics of 1031s. I know enough to be dangerous, so to speak, on those. But the 1031 is a great process if you want to defer you want to defer capital gains taxes. That's a way that you can take your investment and continue to reinvest it. If you're wanting your money out, if you're wanting to be done with investing, then obviously a 1031 is not for you. If it's just, I'm done, my use for this property is over, and I want to reinvest that into a different kind of property, then that's a great avenue to use. So you can defer those taxes until later on. It's something that needs to be planned. People think that, hey, I've got this property that was a rental, I just sold it, now I want to put it in something else. Well, it's too late. Once you've already gone through and done that for sale, the 1031 is off the table, really. You have to have an intermediary, a disinterested intermediary. So it can't be, the attorney that you've used before or the accounting firm that you've used before to provide advice to you. You always have to have a disinterested intermediary that essentially holds the funds from the sale and reinvest those on your behalf into the new purchase. Although the intermediary holds the funds, they are not involved in the chain of title. So the contract that you have for the sale of your house gets assigned, or your property, I should say, it gets assigned to the intermediary, and same with the contract for the replacement property gets assigned to the intermediary. But that agreement provides that the deeds go directly from seller to buyer, and from buyer to that kind of an arrangement for both the current property and the replacement property. The other thing that I think some people don't realize is that in a 1031 exchange, your debt and equity have to be the same on a replacement property as the current property. So if you go to sell your property,
or more, right? Or
yeah, exactly.
Yeah.
Yep, or more. Yep.
Yeah.
Yep, that's right. Some people think, well, I'm going to sell this property, pay off my debt, and then reinvest these funds into the replacement property. Well, that doesn't really work, and you're not going to save the capital gains taxes that you think you're going to. I think there still will be some savings, but it will not fully prevent the full capital gains tax from hitting. So
interesting. So yeah, those are all good things. So if you're listening today and you ask yourself that question, well, if I need an attorney, call Ronnie, because he'll help you out. So, dude, this has been fun. There's so many. We didn't even get a chance to hit hardly half the stuff that we were going to talk about today. But we'll definitely have to do this again and hit some crazy topics, that we had on our list here. So, you guys, if people want to get a hold of you, Ronnie, where can people reach out to you?
Sure, absolutely. Appreciate the plug, JP. Our number 307-638-7745. Great place to call. My email is ronnie@performance-law.com. Awesome.
Well, man, I appreciate your time. Look forward to doing this again soon, not 9 months from now. and we will definitely chat soon. And let me see here. Let me cue my outro music here. So there we go. Well, thanks again, guys, for joining another episode of the Success Agents Podcast. And we will catch you guys all on the next episode. Bye now.